Picture this. It's a Tuesday morning. A woman named Maria walks into a federal courthouse in Ohio. She's 43. She's a nurse. She's been a nurse for 20 years, and she owes $140,000 in medical debt. Not because she was reckless, not because she went on some spending spree, because her daughter got sick, and the insurance didn't cover what it was supposed to cover, and the bills kept coming, and the interest kept compounding. And by the time she looked up from the paperwork, she was underwater by 6 figures. Maria sits down in a courtroom. She's expecting to be judged. She's expecting someone in a robe to look at her like she failed. And here's what happens instead. The judge reviews her case, runs through her income, her assets, her debts, and then does something that no other court in the American legal system does. The judge erases her debt. $140,000, gone, like it never existed. But here's the part nobody tells you. In that same proceeding, in that same courtroom, that same judge also takes Maria's savings account, her second car, and a small piece of property she inherited from her grandmother. The court gives those things to the people Maria owed money to. Not all of it, not even close to what she owed. But whatever the court could grab, it grabbed. So let me ask you something. What kind of system forgives you and strips you at the same time? What kind of system says you're free and hand it over in the same sentence? That's bankruptcy. And almost nobody understands how it actually works. Here's the thing most people get wrong about bankruptcy. They think it's a punishment. They think it's what happens when you lose, when the system finally catches up to you. But that's not what bankruptcy is. Bankruptcy is one of the most bizarre contradictions in the entire American legal system. It's a process that exists to do 2 things that directly conflict with each other. The first thing is to give people a fresh start, wipe the slate, let them walk away from debt they can't pay and rebuild their lives. The second thing is to protect creditors, the people and companies who are owed money, to make sure they get paid as much as possible before the slate gets wiped. Fresh start for the debtor, maximum recovery for the creditor. Those 2 goals are at war with each other, and bankruptcy is the machine America built to manage that war. So, here's what we're going to do. I'm going to show you how that machine works, what happens inside it, what it does to real people. And then I'm going to show you why, despite being over 200 years old, it still doesn't fully resolve the contradiction it was built to handle. And that's not a failure. That's actually the point. Let's start with the 2 sides. On one side, you've got the idea of a fresh start. This is ancient, like literally ancient. The concept of forgiving debt shows up in the Bible, in the Torah, in Roman law. The idea that a person who can't pay shouldn't be crushed forever. That there's a point where the punishment stops and the rebuilding begins. America's founders felt this strongly enough that they put bankruptcy in the Constitution. Article 1, Section 8 gives Congress the power to establish uniform laws on the subject of bankruptcies. That's right there in the original document, next to the power to declare war and coin money. They thought it was that important, and here's why. In the 1700s, if you couldn't pay your debts in England, you went to prison. Debtor's prison. You sat in a cell until someone paid your debts for you, which almost never happened, so you just sat there. The founders looked at that and said, no, that's not how this country works. People take risks. People start businesses. People borrow money to build things. And sometimes those things fail. And when they fail, the person who failed needs a way out, not to escape responsibility, but to stop the bleeding so they can try again. That's the fresh start. It's baked into the DNA of American law. But here's the other side. And this is where it gets uncomfortable. Every dollar Maria owes, someone else is owed. Her hospital is owed. Her credit card company is owed. The contractor who fixed her roof is owed. Those aren't abstract entities. The hospital employs nurses just like Maria. The contractor has a family. When Maria's debt gets erased, those people lose money, real money. money they earned, or lent, or are counting on. So creditor protection says, wait. Before you wipe everything clean, let's at least make sure the people who are owed get whatever we can give them. If Maria has assets, let's distribute them fairly. If Maria has income, let's see if she can pay back at least some of what she owes over time. Don't just let her walk away with everything while the people she owes get nothing. That's wild when you think about it. Both sides are completely reasonable. Both sides are completely incompatible. And the entire bankruptcy system exists in the gap between them. I'm going to be honest. The first time I tried to understand how the system navigates this contradiction, I had to read the same chapter of the Bankruptcy Code 3 times. It's not that the concepts are hard, it's that the system is deliberately complex because it's trying to do two opposite things at once. But here's the version that actually makes sense. The system resolves the tension by sorting people into categories. Different categories get different machines, and each machine balances the fresh start and creditor protection differently. The first machine is called Chapter 7. This is what most people picture when they hear the word bankruptcy. It's sometimes called liquidation. Here's what happens. You walk in. A court-appointed trustee looks at everything you own. They separate your stuff into two piles. One pile is exempt, meaning you get to keep it. Your primary home in most states, your basic car, your clothes, your retirement account, tools you need for work. The other pile is non-exempt. That's the stuff the trustee can sell and distribute to your creditors. Once that's done, the court discharges your remaining debt. It's gone. You walk out owing nothing, but also owning less than you walked in with. Quick pause. Let that sink in before we move on. The second machine is Chapter 13. This one works completely differently. Instead of liquidating your assets, Chapter 13 says, okay, you have income. Let's build a repayment plan. You'll pay back a portion of what you owe over 3 to 5 years, and at the end, whatever's left gets discharged. The key difference is you keep your stuff, your house, your car, everything. But you're on a strict budget for years. The court controls your financial life. And then there's the big one. Chapter 11. This is what companies use. This is what Purdue Pharma used, what General Motors used, what every airline you've ever flown has probably used at some point. Chapter 11. Lets a business keep operating while it reorganizes its debts. The company proposes a plan, the creditors vote on it, and if enough of them agree, the court can approve it. The business survives, jobs are saved, but creditors often get pennies on the dollar. Now here's something most people don't know. You don't just get to choose which chapter you want. The system has a filter called the means test. It looks at your income, your expenses, your family size, and it determines whether you qualify for Chapter 7 or whether you have to do Chapter 13 instead. If you make too much money, the system says you can afford to pay back at least some of your debt, so you don't get the quick wipe. You get the repayment plan, and before any of these machines even start running, something extraordinary happens the moment you file. It's called the automatic stay. The second you file for bankruptcy, every single creditor has to stop. Stop calling you. Stop suing you. Stop garnishing your wages. Stop foreclosing on your house. Everything freezes. It's like someone hits a pause button on your entire financial life. I'm not going to pretend I find this easy to explain, because the automatic stay is one of those things that sounds simple, but has about 40 exceptions that lawyers argue about constantly. But the basic version is this. Filing for bankruptcy builds an immediate wall between you and everyone you owe. Stay with me. The next part is where it actually clicks. So the system has these machines. Chapter 7 for liquidation, Chapter 13 for repayment, Chapter 11 for businesses, the automatic stay for immediate protection, the means test for sorting. It sounds like it covers everything, right? It sounds like the contradiction is resolved. Fresh start on one side, creditor protection on the other, and the system balances them. Except it doesn't. Not really. Here's where the cracks show. And this part still blows my mind. Student loans. If you're a person named Alex, who just graduated with $90,000 in student debt and you can't find a job that pays enough to cover it, bankruptcy will almost certainly not help you. Student loans are famously almost impossibly difficult to discharge in bankruptcy. You have to prove something called undue hardship, which is a standard so high that most courts interpret it as you are permanently disabled and will never be able to work again. Congress decided in the 1970s that student debt is special. Not because it's smaller than other debt. It's often bigger than a mortgage. Because they decided it is, that's a policy choice, not a legal inevitability. And it means that the Fresh Start has a giant asterisk next to it for an entire generation of Americans. Then there's the Purdue Pharma case. This is the one that rewrote the rules in 2024. Here's the story. The Sackler family owned Purdue Pharma, the company that made OxyContin. Between 1999 and 2019, roughly 247,000 people in the United States died from prescription opioid overdoses. The Sacklers saw the lawsuits coming, so they did something breathtaking. They pulled approximately $11 billion out of the company and moved it into personal trusts, many of them overseas. Then the company, now drained of most of its value, filed for Chapter 11 bankruptcy. And here's the move. As part of the reorganization plan, the Sacklers offered to put about $4.3 billion back in. But in exchange, they wanted every single opioid victim in America to be permanently banned from ever suing them. Personally, the family, who never filed for bankruptcy themselves. Imagine you take all the money out of a house, set the house on fire, and then ask the fire department to not only put out the fire, but also give you a certificate saying nobody can ever blame you for the fire. The Supreme Court looked at this in 2024 and said no, 5-4. Justice Gorsuch wrote that the Bankruptcy Code does not give courts the power to release claims against people who aren't the ones going bankrupt, not without the consent of the people who are owed. That decision changed the landscape of corporate bankruptcy overnight. For decades, big companies had used this exact playbook: mass tort, billions in liability, bankruptcy filing, third-party release for the owners. After Purdue, that door is closed. But here's what that reveals about the paradox. The system that promises a fresh start was being used by billionaires to get a fresh start they didn't earn, at the expense of victims who never got one. The machine built to balance two conflicting principles was being gamed by the people with the most resources to game it. And the Supreme Court had to step in and say, this isn't what the machine was designed to do. There's a whole rabbit hole here involving something called the Texas two-step that I'm not going to drag you into today. But the short version is that Johnson & Johnson tried a similar move with their talc lawsuits, creating a subsidiary specifically to file for bankruptcy and absorb liability. And a Texas bankruptcy court rejected it 3 times. The system is actively fighting over its own boundaries right now. And that's the answer to the paradox. The system doesn't resolve the contradiction between forgiving the debtor and protecting the creditor. It manages it, case by case, year by year, Supreme Court decision by Supreme Court decision. The tension is permanent. The architecture of bankruptcy law is, honestly, one of the most elegant compromises in the entire legal system. It doesn't try to be fair. It tries to be survivable. And there's a difference. So what does this actually mean for you? If you ever face a situation where your debts are overwhelming, bankruptcy isn't the end. It's a legal tool, a machine with specific inputs and outputs. Chapter 7 wipes the slate, but takes your non-exempt assets. Chapter 13 lets you keep everything, but puts you on a court-supervised budget for 3 to 5 years. Chapter 11 is for businesses. The automatic stay stops creditors cold the moment you file. The means test determines which path you qualify for. And the whole thing stays on your credit report for 7 to 10 years, which is real, but not permanent. Every state and every fact pattern is different. What you just learned is the framework, not the answer. Now let me clear up the three things almost everyone gets wrong. The first one is that bankruptcy means you lose everything. You don't. Every state has exemptions. In some states, you can keep your entire home. In Texas and Florida, for example, the homestead exemption is unlimited. You could own a mansion and keep it in Chapter 7. The details vary wildly by state, but the idea that you walk out with nothing is a myth. The second one is that only irresponsible people go bankrupt. Study after study shows that the majority of personal bankruptcies are triggered by medical debt, job loss, or divorce. Not credit card binges, not bad decisions. Life events that can happen to anyone. If your head is spinning, you're not alone. Mine spun the first time I read the research on this too. The third is that bankruptcy erases all debt. It doesn't. Student loans survive in almost every case. Child support survives. Alimony survives. Recent tax debt survives. Criminal fines survive. Debts you incurred through fraud survive. The fresh start has more exceptions than most people realize. If you want to actually understand the deeper logic of how all these pieces fit together, there's a book called The Logic and Limits of Bankruptcy Law by Thomas Jackson that explains why the system is designed around these trade-offs. It's academic, but it's the clearest thing I've read on why bankruptcy works the way it does. So let me bring this back to where we started. Maria walked into a courthouse in Ohio, owing $140,000. She walked out owing $0. But she also walked out with less than she had. Her savings account went to creditors. Her second car went to creditors. A piece of property her grandmother left her went to creditors. And her credit report will carry the word bankruptcy for the next 7 years. Was that fair? That depends on who you ask. If you ask Maria, she'll tell you it saved her life. If you ask the hospital that wrote off $100,000 in charges, they'll tell you the system cost them. If you ask the founders who put bankruptcy in Article 1 of the Constitution, they'd probably say, that's exactly how it's supposed to work. Nobody gets everything they want, but everybody gets to survive. That's the deal. That's always been the deal. Most people will go their entire lives without understanding this system. They'll sign credit card agreements, take out mortgages, co-sign loans, and never think about what happens if the bottom falls out. And then one day, maybe, the bottom falls out. And they Google bankruptcy at 2 in the morning, terrified, ashamed, thinking their life is over. If this video reaches one of those people before that night, then it did what it was supposed to do. Because understanding the machine before you need it is the difference between panic and a plan. And if you're the person in your family who now knows how this works, you've changed every conversation about money, debt, and failure that your family will ever have. That's not a small thing. This is education, not legal advice. If you face a real situation, talk to a licensed attorney in your state. They'll know the exemptions, the means test thresholds, and the local rules that can change everything. But now, at least, you know what questions to ask.